This is an appeal in the matter of InterDigital Inc. and Appellant UK Limited and others.
My Lords, can I begin by introducing the respective counsel?
Yes.
I'm instructed on behalf of both InterDigital and Nokia, who have separate but similar appeals.
Yeah.
Sarah Abram, King's Counsel, my right, appears on behalf of Qualcomm. Henry Ward appears on behalf of Google, Huawei and LG Electronics. We are the appellants, and Brian Nicholson, King's Counsel, and Tom Jones appear on behalf of Apple and Optis, respectively.
Yeah.
As my Lords will be aware from the materials filed, several unusual features.
Yes.
None of the appellants was formally a party to the action below. Secondly, there are no substantive respondents. Optis and Apple do not oppose the appeals and hence are merely nominal respondents, and there's an order to that effect, and they've produced a helpful note. Your Lordships may have noticed the notice of appeal were filed before there's an actual order because of concern that the information in question was about to be published imminently, but nothing turns on that now. What is not unusual is the nature of the key issue, which is the redaction of third-party confidential information consisting of royalty payment terms and patent licenses, and also unpacked rates derived therefrom from court judgments handed down in FRAND cases. And there is a wealth of case law on this topic, not just after judgment, but at interim stages where applications are made for disclosure of such information in FRAND proceedings, and the courts make suitable confidentiality arrangements to protect the confidential information. Now, InterDigital's license ran from 1st October 2016 to 30th September 2022, so it was still in force during June-July 2022 when much of the first instance trial took place, although it's expired now. I will refer to that as the 2016 to 2022 license, that being a more accurate description than merely 2016. Nokia's license ran from 1st of January 2017 to 1st of January 2024, so it's more recent and was still in force at the time of the hearing before the judge in July 2023. The licenses of the other appellants have different start and end dates, but I won't go through them all now. In terms of approach, the court has ordered that the parties liaise prior to the hearing to conduct oral submissions in a way that minimises duplication. To that end, I've agreed with Ms. Abram, King's Counsel, Mr. Ward, that I shall lead on the legal submissions as regards actual royalty payments and unpacked royalty rates. Ms. Abram has indicated she would like to add some submissions of her own on behalf of Qualcomm, and she estimates 20 to 30 minutes for that. Mr. Ward reserves his position, but is likely to be brief on that topic. And then I will deal with some client-specific points, which are specific to InterDigital, which go to a mistake made in the judgment when describing the terms of InterDigital's license. And Ms. Abram, King's Counsel, Mr. Ward also have some client-specific points. Then it will be open to Dr. Nicholson and Mr. Jones to respond if and to the extent they see fit, and formally the appellants would have a right to reply if needed. I wonder if my Lords have received a helpful note prepared by Optis and Apple. I'm grateful. I should begin by defining the word unpacking, which is frequently used in this area of law. It'll be familiar to my Lord Justice Birss, and I will borrow from an explanation he gave in the substantive appeal from the judge's FRAND determination. I don't propose to go to that, but I'll try to summarise it myself.
That's in the bundle towards the end of core bundle 2, isn't it?
Yes, it's the actual reference core bundle tab 13. I'm going to go to that in a minute, but unless it assists my Lord to go to paragraphs 12 to 13 of that. Is my Lord
The
happy
Court of
now?
Appeal judgment.
Yes. Well, if the Lords are there, the explanation of unpacking is it's core bundle tab 13, page 498, paragraphs 12 to 13. And I won't read it all out, but it's essentially the process of converting royalties expressed in one way in the license, for instance, as a lump sum, into a figure expressed in another way, for instance, an ad valorem rate, which is a percentage of the sales price, or a fixed sum per unit, such as $1 per unit. And the reason it's done is, of course, to ensure that all of the royalty payments being considered are expressed in the same sort of units. But as is stressed here by my Lord Justice Birss, it's more complicated in real life than in theory. In theory, it could be done perhaps with mathematical precision. If it's a backward-looking license, you just look at the lump sum and how many units they sold, for instance, and you might be able to work it out. But there's a variety of reasons why it's not that simple. For instance, the agreement might cover additional rights, which have nothing to do with a FRAND obligation. Might include a cross-license. It's always forward-looking to some extent, so it must rely on estimates of sales rather than actual sales. There might be discounts for early receipt, bulk discounts, specific regions, discounts for the past, all sorts of party-specific reasons to do with timing of cash flow, or perhaps one side simply struck a better bargain than the other. So it follows in the real world there never is a mathematically precise figure, merely a useful figure, which enables comparisons between different real-world licenses. And if I could show my lords another paragraph from this judgment, the appeal judgment, paragraph 89, at page 512. This is actually dealing with the judge's treatment of the valuation experts, but that's not why I'm going to it. Towards the bottom of the page, my Lord Justice Birss, with whom Lord Justice Arnold agreed on this, and indeed Lord Justice Newing as well. I'm just reading out from 4 lines up. The two experts approach matters in essentially the same way, no doubt based on their own experience in other cases, both trials and arbitrations. Their skill is in grappling with the financial details of the kinds of licenses in issue in order to extract what, in their expert opinion, will be useful information for the court. This is the task of unpacking. And that way of looking at unpacking my submission is more general and focuses attention on the point of the exercise. It is not a mechanical conversion exercise. It is about extracting the useful information from these licenses so that the court can reach its judgment. I should also define the term third party, which is relatively simple. When I refer to third party confidential information, I intend to distinguish information which is merely confidential to the parties in the action themselves, and information which is confidential to third parties, such as my clients, indeed all the appellants, who have no control over its deployment or treatment at the FRAN trial. In terms of legal context, my lords will be aware there are 2 first instance cases on the key issue about redactions and judgments. That's a decision of Mr. Justice Birss then was in Unwired Planet, and a decision of Mr. Justice Mellor in InterDigital and Lenovo. There are also at least 2 cases in this court where similar redactions have been made from the court's judgment, but in neither of those instances has this court previously considered the principle thereof. I won't be referring the court to any foreign judgments on this topic because although there are increasing numbers of foreign court decisions, for instance in the Chinese courts, so far as we are aware there are no instances of any foreign court publishing this type of confidential information. That's a point made by Mr. Ridgway of the A&O counterparties, SUP 110.176, paragraph 41. The 2 cases of this court to which I refer, where such redactions have been made, are the appeal in InterDigital and Lenovo, which is the appeal from Mr. Justice Mellor's substantive decision, and also this court's substantive judgment in the main appeal between Optis and Apple in this very case. The latter of these raises a specific point of housekeeping to which I will return, but for the moment I will continue with this general introduction. There is also this court's judgment in Bamford and Manitou. This was not a FRAN case and did not involve any third parties. It was a case about CPR Part 3122.2, whereby the court can restrict the subsequent use of parts of various documents read or referred to at a public hearing, and in particular it considered the impact of the Trade Secrets Directive upon the conduct of legal proceedings in the UK. The first question...
refers to my Lord's judgment in Unwired Planet and also Mr. Justice Mellor's judgment in InterDigital.
Yes.
It doesn't begin to suggest that either of them is wrong or somehow doesn't any longer represent the law.
No,
which
and
is why the sort of old law, new law point is a rather.
absolutely, and we rely on the correctness of these. That's our first ground of appeal, in fact. As my Lady Justice Falk identified in her order granting permission, one question which does arise is whether the approach taken at first instance in these two very cases my Lord has just mentioned has been affected in any way by this court's decision in Bamford and Manitou. And we respectfully say, no, it's not been affected. You've now got two routes, the Unwired Planet InterDigital route and the Bamford route. I already adverted to the fact my first ground of appeal relies on the correctness of Unwired Planet InterDigital. The judge called this the old test. My second ground of appeal, again for both of my clients, and again for all the appellants, is the judge wrongly applied this court's ruling in Bamford. And that case is of wider potential application than the first two. And the judge referred to that as the new test at paragraph 36 of the judgment under appeal. What I propose to do is deal with ground two, which is Bamford first, and then ground one. And the reasons don't particularly matter, but I'll tell my Lord anyway. The first reason for doing so is that Bamford is a decision of this court, not merely first instance, and part of my appeal is the judge misapplied it. The second reason is that if Bamford has changed the approach in the Unwired Planet and InterDigital and Lenovo, which we don't say it does, then it must have done so in a way which increases rather than reduces the protection given to confidential information. And thirdly, if I win on Bamford, pragmatically it may not be necessary to consider the previous cases at all, although I'm still going to address my Lords on them. And just running through the grounds by way of introduction, InterDigital's ground 5 challenges the judge's view that the protectability of the unpacked rates depends on the ease with which they can be reverse engineered. And there's some law on this, but our submission is that was an irrelevant consideration. It was irrelevant because the unpacked rates were derived from my client's confidential information and are therefore also my client's confidential information. Finally, on this point, Nokia's ground 4 is a refinement on this, which is even if the difficulty of reverse engineering is relevant, which we say it's not, and even if it is difficult to reverse engineer, that still makes no difference because the vice is the same. Third parties will assume the figure derived from Nokia's confidential information is reliable, even if it is not, and Nokia will find it difficult to rebut that argument without disclosing the relevant confidential information. Again, on this introductory section, I should point out to the court there is an important factual difference between the judge's treatment of the unpacked rates, which is essentially to ignore them in favour of his own approach to determining quantum, and this court's treatment of the unpacked rates on the appeal from his decision, which was to use them and indeed to criticise the judge for setting aside the common ground of the experts to adopt some form of unpacking. This difference, of course, did not, or rather has not yet led to this court publishing the relevant third-party unpacked rates in its judgment. As I said, I'll return to that. Moving beyond royalty rates, as I've indicated, there are various issues which are specific to each appellant. For instance, InterDigital, but not Nokia, has a point about an error in the judge's judgment which relates to InterDigital's confidential information. This is InterDigital's grounds 3 and 4 and goes to a short part of the judge's Annex 3. Ground 3 criticises the judge's test as formulated by the judge, and ground 4 points out the judge did not apply his own test. The reason why this is raised as part of the appeal rather than under the slip rule provided in part 40.10 is because although the judge refers to the slip rule, it doesn't appear that he regarded the relevant mistake, or I should say mistakes, as being accidental within the meaning of that rule. It was a positive judicial decision not to make the correction which was requested by InterDigital and which was not opposed by either Apple or Optis. And on the mistakes issue, there are two issues. First, whether to make the correction at all, and secondly, whether to publish the relevant information. The latter, the decision to publish, needs to be appealed in any event because the judge's decision was to publish it. We respectfully submit the information should be redacted in any event, but that factually incorrect information about InterDigital's license should certainly not be published in a court judgment. So far as we're aware, there's no law on the issue of whether a non-accidental slip or omission should be corrected in response to requests from a third party, particularly when the information in question is expressly said, and it's not disputed, to be confidential. Where the request is made by a party to the action, the remedy would be appeal in the normal way. But having said quite a lot about mistakes, the point is actually a short one when we get there. I should point out that the judge at first instance was concerned the present appellants might have no right to appeal at all. For instance, he deprecated the use of the term third parties to describe the various appellants.
This court has recently dealt with the authorities on appeals by non-parties in a case called Andrew in the Federal Republic of Nigeria, which refers to W and the other cases. Speaking for myself, it was pretty clear that you had locker standby for appealing. So unless my lords want to hear anybody on that issue, you can take it as read that we accept that you have a right of appeal.
I'm very grateful to the court.
It's clear that you're a party or you are all parties who potentially suffer considerable prejudice if your appeal is correct, and therefore it seems to me you have a right of appeal.
I'm grateful, my lord. I mean, we did appear in oral submissions before the judge as well, but I'm very grateful. A couple of final housekeeping points, and one of them is what to do about the court's substantive judgment in the main appeal with Optis and Apple, which I already mentioned, already taken the court to parts of it. Now, that judgment has redacted certain confidential information, principally unpacked royalty rates, expressed in terms of dollars per unit, and 5 agreements in particular have been redacted: Google, Ericsson, IDG, Nokia, Sysville. And the top of that judgment stated that these redactions will be reviewed after this present appeal that the court is now hearing. My clients weren't aware until relatively recently of the precise mechanism by which the redactions in this court's substantive appeal judgment would be resolved. But we now know that under paragraph 11 of an order made on 1st of May 2025, that's going to be reviewed. That, in other words, the status of the redactions, that other judgment will be reviewed after the conclusion of the present appeals. And that means that formally the issue of what to do about the redactions in that judgment is not before this court. We did, however, write, when I say we, it was Solicitors InterDigital on behalf of all appellants, wrote to the court on 5th of June, explaining that in our view, the redacted information in that other judgment is equivalent to the redacted information in the judgment which is an issue on this appeal, and offering to provide written submissions. But the court's reply from Lord Justice Arnold's on 12th of June directed it was not possible for this court to form any view on that question, in other words, what to do about the other judgment, raised in advance of the hearing of these appeals. And then we should take the course we judge will be of most assistance. Now, I will be referring to the redactions in that judgment, not directly to support them, but to commend it as a good way of how to proceed. But I appreciate the final decision about what to do in that other judgment is a matter for another day. And although my clients remain of the view that this present appeal will effectively determine what is likely to happen about that other judgment, they formally reserve their position because, for instance, Ericsson and Sysville are not here today, but they're potentially affected by that other judgment, and they may wish to say something. The second housekeeping point is I would ask for another order under Part 3122 in this appeal. A draft has been agreed between the parties, and I can hand it up to the court. That's to protect confidentiality and information that forms the subject matter of this appeal pending the court's judgment. That's being asked for on a pro tem basis until the court gives its judgment. I can either hand it up or it can be deemed to be handed up as the court prefers.
Whenever it's convenient.
I'm grateful. I mean, certainly if the appeal succeeds, I would ask for a permanent order to that effect, but we can worry about that when we get there. And finally, I don't believe it would be necessary either to read out royalty payments or unpacked royalty rates, since the precise value of the numbers doesn't make any difference to the argument, so I won't do that. For the mistakes, however, the textual content does matter.
Yeah.
Now that completes my introduction. I was now going to go to the substance of the appeal, and to do that by reference to looking at the judgment under appeal itself. And this, of course, is a core bundle 2, tab 12. And if I can invite my lords to go to paragraph 10 on page 442. All references will be to the bundle unless otherwise stated. I know my lords will have read this, so I'm not going to read it all out. But the judge rightly states here that the comparable licenses formed an important element underlying the reasoning of the judgment, and it would not be overstating matters that the answer to the Frowned question could not have been obtained without these comparables. And this obviously underpins his reluctance to redact any aspect of it. Moving on to paragraph 13. This is where the judge first sets out his view, as we see from the second line, that his judgment finds that unpacking was a subjective and highly unreliable process. And his view that it was subjective and highly unreliable later forms part of his reasoning as to why the unpacked rates in particular were not protectable, or at least not worth protecting. I would respectfully say the suggestion that the figures are, quotes, highly unreliable, the figures for unpacked rates, should be put into context. If my lords turn on to the next tab, which is the court's substantive appeal judgment, there's a number of important findings again by my Lord Justice Birss, with whom Lord Justice Zacaroli agreed. If my lords go to paragraph 96 on page 514. Says, finally, it has to be pointed out, as is plain to anyone reading the judgment as a whole, that having called the three subjectivities of unpacking insurmountable when rejecting the evidence, in fact, handling them somehow always was unavoidable, and so when the judge came to work through his own method, he had to grapple with all three one way or another. So any suggestion that subjectivity of itself means the unpacked rates can or indeed should be disregarded, we would say is plainly wrong. On the contrary, they're important tools, they being the unpacked rates, important tools to assess licensees, but also important tools for competitors to use their, to their benefit in future negotiations if made public. Another paragraph to which I wish to draw the court, paragraph 115, and here my Lord Birss sets out the first sentence, the right approach, and in the second sentence, moreover, there was no justification for setting aside the common ground of the experts to adopt some kind of unpacking to evaluate licenses in per unit terms. So although the judge himself set aside that common ground in favour of his own approach, this court has held he was wrong to do so. Now, just pausing there, respectfully submit the court needs to distinguish between two distinct concepts. The unpacked rates are, of course, central to the court's reasoning as to how it arrives at a particular figure, but it does not follow with respect that each of the unpacked rates is itself essential to the public understanding of the court's reasoning. And this emerges from the third point of this appeal judgment upon which I seek to rely for present purposes. If I was could go forward to paragraph 137, I appreciate this is, the redactions here are all a matter for another day, but I'm going to say that this court's substantive judgment provides a useful example of how the court can approach such matters. And in particular, why should we use an artificial example when a real one is available here? My submission is going to be that the court doesn't need to reveal the actual unpack rates in order for the public to follow the first instance, or indeed this court's judgment. But I mentioned para 137. There's no redactions in 137 itself, but here Lord Justice Birss refers to the unpack rates in 4 Apple licenses with Ericsson, InterDigital, Nokia and Cisco. And this paragraph doesn't set out the actual dollars per unit DPU rates for these 4 licenses. It doesn't need to. The point is they are appreciably higher than the figures given here of 2 cents or 1 cent. And then the next part of the court's reasoning is in relation to the Google license, which was a license in Google and Optis. Again, this doesn't set out the Google Optis rate either, but it's apparent from what is written that it's higher than the Apple licenses, and the Frand answer is between the two, as pointed out in the last sentence of 139. And then turning the page, page 523.
Mr. Campbell, can I just make sure I've not misunderstood something? You're looking at where you took us to 137 and 138.
Yes.
Your version of 134, which is on the same page, your version has blanks, where my version has numbers.
Not quite. I have the figures. This is one of the admin points for the appeal. I have the numbers for InterDigital and Nokia because I'm allowed to know these.
I see. Yes, I see.
But I'm not allowed to know the others.
So your figure on the top there says Ericsson, InterDigital, Nokia system of blank, and then a number, then another number, and then blank again.
Correct. And that's
Okay.
in 134. It's the second and fourth line.
Colleagues have different things from yours.
Correct. And that's a point we'll come to again. The court and Apple and Optis, they have it all unredacted, but we don't.
Yeah.
But moving on from 140 onwards, then Lord Justice Birss goes through some more detailed calculations using the stack price. And again, there is redaction in my version, but what one can see is that 27 cents DPU is too high. One gets that from 142 to 143. And then the court considers a DPU of 20 cents per unit and concludes that's not right at 144. And finally lands at 15 cents per unit in 145. And in 144 and 145, no redactions. But then what one sees, once the court decided it's 15 cents, the actual figure converted into lump sum is dealt with in the next part of the judgment. And if I always look at 147 to 148, the figure there of $502 million appears in the last line of 148. So there's 2 points here, but the first one is that the unpacked rates are not, quotes, highly unreliable, close quotes, information, as the judge at first instance believed. The Court of Appeal not only relied on them, but used it to justify a payment of just over $500 million from Apple to Optis. And that is entirely conventional in this line of law. It's consistent with other Frand judgments of the UK courts, which have all used unpacked rates to arrive at the Frand terms. But for the same reason they have been useful to the court in these cases, they are also useful to competitors seeking to utilise them to their advantage in future negotiations, which is precisely the vice that their submission justifies their redaction. And if one thinks about it, the unpack rates are actually of far more utility to a competitor in a future negotiation than lump sum. Because if there was a hypothetical negotiation for a new license, the new licensee would be interested to know, well, how much was actually paid under the existing license? But we'd ask follow-up questions such as, well, how many units were sold? What were the projected sales? What was licensed? Was there a discount? In other words, the licensee would actually want to know the unpacked rates and would consider all the same points as were considered by the parties experts in this case, and indeed considered by the parties experts in all FRAP cases, when attempting to extract the useful commercial information. But my second point is that using this worked example, the public doesn't need to know the precise unpacked rates any more than it needed to use the license payments. All it needs to know is what it can see from this judgment, that the FRAND rate was higher than some licenses, which are identified, lower than others, and if we successively consider a figure of 27 cents, 20 cents and 15, then the court can conclude that 15 cents was correct. Now, having looked at that work example, go back to the judgment under appeal to see what the judge did. This is back in Core Bundle 10, and if I could invite my lords to go to page 443. And, sorry, I said 10, I meant 12.
12.
Now, the next section of the judgment under appeal, running from paras 15 to 20, sets out the regime used to protect third-party confidentiality during the trial. Now, the point made in paragraph 15 is that the licensees themselves have provisions for protecting confidentiality, which is fair. But as the judge goes on to say in paragraphs 16 to 18, the court used a confidentiality regime in order, as the court put it in paragraph 16, quote, to procure voluntary compliance of the Optis Apple counterparties with the court's disclosure regime. That's lines 3 to 5. And although the judge doesn't say so here, the relevant confidentiality regime was both elaborate and carefully negotiated over a period of time. It's in the sub-bundle at tab 25, page 372, and I don't think we need to look it up. It's entirely typical of the types of arrangements regularly made in this sort of case to protect the confidentiality of comparable licenses of this kind.
Zacaroli, what do you understand the judge to mean by voluntary? I mean, I understand that the regimes were negotiated, and no doubt bits or maybe all of it was agreed to in the sense of agree to a regime, but it doesn't mean quite the same thing as voluntary. I find it a bit hard to believe that any of your clients really voluntarily could be said to voluntarily documents for the court.
I think
really
there's,
I mean, these are documents in disclosure. They were going to be in disclosure, whether you liked it or not. Now, in a situation in which it was going to be there whether you liked it or not, you negotiate a regime. I'm just not sure that I find the word voluntary very helpful in that context. But
well, it certainly wasn't that we woke up one day and thought it was a jolly good idea. What we wanted,
my lord says the documents that would have been either Optis or Apple were obliged to disclose anyway, pursuant to their disclosure obligations under the CPR. So it's not voluntary disclosure in any sense. It's just disclosure pursuant to the CPR, and the confidentiality that's being protected has got nothing to do with the voluntary disclosure point, because it's to do with the fact, so far as your clients are concerned, you have no control whatsoever over what's disclosed in the litigation to which you're not a party.
yes, I
But
thought
you have an interest in having confidential information protected.
yes, I think that may be what the point the judge is actually making here, notwithstanding his use of the word voluntary.
Yeah, maybe it's just a they use the word voluntary.
The Lords are entirely right. It was going to be disclosed anyway. And the question was, given that it had confidentiality terms in each of these licenses, what was the best way to manage that process? And the best way to manage that process was by the confidentiality order which was made. And it was quite elaborate. It was 23 pages long. Originally made on 3rd July 2020 and amended twice.
Mm-hmm.
And the reason for that, and just jumping ahead a little bit, one of the points made in the evidence raised by Mr. Ridgway of the A&O parties is that third parties would be much less likely to cooperate with the process insofar as their cooperation is required if they knew that despite all these carefully negotiated protections, their information was going to be published anyway. And there might be more battles at an interim stage, even if, as a matter of law, the parties to the action have no choice but to disclose it.
Yeah. And the party's under an obligation to give disclosure,
Yes.
which includes disclosure of agreements with third parties.
Yeah.
And in a normal course of events, the third party, that's just tough. The third party has no ability to prevent the disclosure of something which a party to the litigation is obliged to disclose. The position here is to do with not to do with whether or not you cooperate in the process, because your cooperation isn't required, is it?
Yes,
Because if Optis or Apple would have had to disclose these documents anyway.
Yes, I follow that, but there may be a distinction between disclosure in the process and publishing the actual information in the final
I
judgment.
understand the point about, and I'm not detracting from the confidentiality, the need for confidentiality. I'm simply questioning whether a consequence of the documents becoming public would be that somehow your clients would stop cooperating, because I'm not entirely sure that there is an element of a cooperation. It's just as long as you continue to have a commercial relationship with one or other of these parties and enter into agreements with them, licenses with them, then it doesn't require your cooperation.
Yes, I follow. As the judge says at paragraph 18 of this judgment, and perhaps this is more the point for today, he says nothing was said about the end product of the process, the judgment itself. The point was never addressed, and the assumptions it appears to have been, at least on the part of the parties in the court, that while the judgment would obviously respect the interests of the Optis Apple counterparties, at the end of the day, the terms of the judgment, what was said openly and what would be redacted, would be a matter for the court. That assumption proved false. A number of days have been spent litigating this collateral matter, and enormous outlays of good time and money have been expended. Just pausing on that. Of course, my clients, I mean, how could they have been expected to foresee how their material was likely to be used in the judgment? We couldn't do that. And for all we knew, for instance, the license to which we were parties might have been held to be irrelevant. And even if it was relevant, it wasn't open to us, or indeed to anyone, to dictate to the court in advance how material should be treated in a judgment. So the criticism that nothing being said about the end product, well, what was likely to be said and by whom? But at the end of this paragraph, the judge does mention and criticise what he says was the enormous amount of, the enormous out-of-court time and money expended.
Just before you get to that, Mr. Campbell, I don't quite understand what the judge means by saying that the assumption proved false. Because surely it's correct to say that no doubt the judgment would respect the interests of counterparties, but at the end of the day, the terms of the judgment will be enough for the court. That's right, isn't it?
Yes, it is.
There's nothing wrong with the assumption.
No, and actually,
the point that the judge is concerned and no doubt entitled to express his concern about how much time and energy has been involved in sorting it out. I get that, and experience shows that that's one of the less exciting parts of litigating these kind of patents cases is arguing about confidentiality. Everybody loves it, but there's something wrong with the assumption.
yes, I agree entirely. In fact, I've got a question mark next to that in my own notes because I thought, well, what was false about it? But whether true or false isn't really the point. The enormous amount of time and money is something of considerable concern. InterDigital, they don't have a cost schedule given the nature of this appeal, but I've made inquiries, and the figures have been given are over 250,000 for confidentiality matters generally, of which about 150,000 has been incurred on this appeal. So the judge is right about the substantial sums. My Lord C, 5 counsel today, the actual hearing I think was 2 years ago in this very court, and it was even more crowded then. Considerably more people came to that. And one of the reasons why in our submission so much time and money has been spent on the confidentialities in this case, particularly on appeal, is because we say that the judge declined to follow the approach set out in the previous cases.
But of course, Mr. Justice Mello had been right that he was effectively laying down what might be described as a sort of template for the future.
Yes.
And the judge had followed that, then it probably wouldn't have cost anything like
My Lord's ahead of me.
the amount of money it's cost.
That's a point for later. I won't make it. Now, just returning to the judgment, the judge sets out some evidence. This actually was from Mr. Robert Earl of Ericsson. But as the judge says, the importance of confidentiality rates is explained in many witness statements from the third parties.
Sorry, where's that, Mr.
Para 20, second sentence.
Thank you.
Now, the judge has set this out. I'll go through it, but I should say that when the judge says many witness statements from third parties, I'll just list them, and obviously don't need to go to it. On behalf of InterDigital, we have witness statement from Ms. Julia Mattis, who's the Vice President, Chief Licensing Counsel in the supplementary bundle SP1, SB1, tab 4, section D, paragraphs 11 to 16. On behalf of Nokia, there was similar evidence from Mr. Richard Very, who was an employee of Nokia until 4th October 2016, is now the partner at Nokia's solicitors, Bird & Bird. That's SB 11206, paras 13 to 17. Also from Mr. Ridgway on behalf of the A&O counterparties, SB 110, 172, 175, paras 18 to 35. And there was also evidence from Miss Heather Muse of Apple to light effect. That's sub-bundle 5, 72 to 75, paras 10 to 18. Apple being a licensee. I've given the reference in case anyone's interested, but I'm not going to take my Lord's to it because it just says the same thing in different words. And conversely, there was no evidence the other way, and in particular, no evidence suggesting the amount paid under licenses was not confidential or valuable information. Difficult to see what that evidence would look like, but as I've said, Apple was the licensee, so they're on the other side of this divide. We're going to what is stated here, again not reading it all out, but perhaps drawing the court's attention to paras 14, 34 and 35, which are cited here now. Paragraph 14, publications of details of a transaction to the world rather than public judgment naturally has the potential to have a much greater impact on Ericsson's business than disclosure on EO basis. This is a distinction between disclosure in the action and the publication in the judgment. And the last sentence, this is the point we discussed a moment ago, that if Ericsson had known in advance that public dissemination would take place, it would likely have strongly objected. That objection may not have gone anywhere, but the evidence is it would have been made. But turning to paras 34 and 35, first sentence of 34, amounts paid under license are the most sensitive parts of the agreement and need to be understood in the context of license overall. Publication of this material would also lead to information asymmetry. And information asymmetry is referred to quite a lot in the evidence. And it simply means that the prospective licensee would know how much Ericsson, in this case, had received from Apple. Ericsson would have no idea what the prospective licensee had paid. And in 35, therefore, in short, publication of that information can only assist the prospective licensee and weaken Ericsson's negotiating position. And the only reason why this is happening, of course, is because Ericsson was a stranger to litigation, but it got dragged into it, and its license was considered to be important. And that only gives a tiny picture of the overall picture of all the licenses that would be in existence. Ericsson would just be unlucky in this sense. And then para 36, a similar point about similar point applies to related financial information. But there's plenty of evidence saying the same thing. Now, the next part of the judgment is the judge's own classification of types of redaction. The only classes that matter to this appeal are classes 1, 3, 4, and 5. Principally, it's 1, 3, 5. We see from class 1 that that's essentially mistakes. The judge refers to the slip rule. That's the point I'll come to at the end on behalf of InterDigital. Otherwise, I'm not going to talk about that one. Class 3, on page 447, that's the lump sum royalties payable in the relevant licenses themselves. I only mention class 4 because it refers to Annex 3, and the InterDigital mistake is in Annex 3, but class 4 isn't otherwise important. And class 5 is the heading. The judge's heading is workings using lump sum rates. That's the one in particular which relates to unpacked rates. And then, as we'll see, the judge deals with class 3 under the old law first, and then under the new law. And I'm actually going to do it the other way around for the reasons already given. We'll cover both. So far as Bamford is concerned, what I would like to do is leave the judgment rule and look at Bamford. And that, in the Joint Authorities Bamford tab 6. Now, I suspect my Lord will have had some opportunity to review this, so again I'll try and go relatively quickly. In terms of background, we use the first 2 sentences of the head note. Claimant brought a claim alleging that 4 of its patents were infringed by 5 different configurations of the control systems of the defendant's telehandlers. So it was a straightforward claim about infringement of mechanical patents. But just to summarise, the details of the defendant's alleged infringing products, these telehandlers, were the subject of a confidentiality regime during trial. Now, the head note makes 2 important points, both which sidelines. The first point, and I particularly refer to G to H, is all about criterion X, which was the relevant trade secret in this case. But as it says just below G, although the degree of relative confidentiality attaching to criterion X as recorded in the confidential annex was not high, in that possession of the confidential annex would give someone a head start of mere weeks or days rather than months or years over someone who attempted to deduce criterion X from a detailed inspection of configuration C telehandler. That did not mean it was not confidential at all. So we're talking about a rather low degree of confidentiality in this case. Turning over the page, this is the key point, and obviously we'll look at this. Allowing the defendant's appeal, it was well established there was an exception to the principle of open justice where this was necessary to protect trade secrets, even if this requires redaction in a way which makes it impossible for the public to understand the details of the court's reasoning. And I'm not going to read more of the head note because we're going to go to the logic, but it comes from the Trade Secrets Directive.
Yeah.
Now, if we turn to the start of the decision, the main decision is that of Lord Justice Arnold. If the laws go to 113 and 114, Lady Justice Elizabeth Lang and Sir Andrew McFarlane, the presidents, they both agreed with it. We marked up quite a lot, but I don't propose to read out everything that's been marked. If I can start at paragraph 35 on page 416. Well, Justice Arnold explains that in his view the case was properly regarded as being about technical trade secrets. One sees the reference to technical trade secrets at the end of paragraph 35, just below the D. And although he does stress technical, we will see that nothing in the logic turns on the secrets being technical rather than commercial. Now, there's a very detailed analysis of the legal principles prior to the Trade Secrets Directive. Again, I don't think we need to spend too long on that because although it's very helpful analysis, all we probably need is the last sentence the last paragraph, paragraph 53 on page 420. In summary, under English law, prior to the implementation of the Trade Secrets Directive, trade secrets simply constitute a particular category of confidential information. And it's distinguished from other forms in the manner set out in 53. Beginning of the section of the Trade Secrets Directive and the regulations is at paragraph 54. And well, Justice Arnold introduces it in 54 and then quotes some various recitals. Now, we've got passages from the directive in the Joint Authorities Bundle at tab 13, but I don't think we need them because they're just the same as reproduced here. So far as recital 24 is concerned, the point is made, the prospect of losing the confidentiality of a trade secret in legal proceedings often deters legitimate trade secret holders from instituting legal proceedings to defend their trade secrets, thus jeopardising the effectiveness of measures, procedures and remedies provided for. That's people who actually institute them, which is obviously not my clients. And then it goes on to say it's necessary to establish appropriate safeguards and so on. Final sentence 24, such protection should reign in force after legal proceedings have ended and for as long as the information constituting the trade secret is not in the public domain. And in 25, it refers to the minimum requirements, and these include, if one would see, one of the things that must be possible is publishing only the non-confidential elements of judicial decisions. In this context, considering that assessing the nature of the information which is the subject of the dispute is one of the main purposes of legal proceedings, it is particularly important to ensure both the effective protection of the confidentiality of trade secrets and respect for the right of the parties to these proceedings to an effective remedy and to a fair trial. So that's the objectives. The substantive articles are then set out, and there's an important one, Article 2. Article 2, a trade secret means information which meets all the following requirements. The first, it is secret, and then it goes on to set out what's meant by that, so it must be secret. B, it has commercial value because it is secret, and C, it has been subject to reasonable steps under the circumstances by the person lawfully in control of information to keep it secret. So three-part definition, which is not tied to technical trade secrets. Now, Article 3 isn't particularly important for present purposes. Article 4.1 is important because member states shall ensure that trade secret holders are entitled to apply for the measures, procedures and remedies provided for in this directive in order to prevent or obtain redress for the unlawful acquisition, use or disclosure of their trade secret. Now, Article 9 is a particularly important one because it refers to legal proceedings. It's quite long. I'm not going to read the whole thing out. I'll just underline a few words. So far as Article 9.1 is concerned, the opening words about what member states are to ensure, but I've underlined the words going from F onwards, are not permitted to use or disclose any trade secret or alleged trade secret which the competent judicial authorities have in response to a duly reasoned application by an interested party identified as confidential and of which they become aware as a result of such participation or access. That, we say, is important. And then it goes on to say the obligation referred to in the first subparagraph shall remain in force after the legal proceedings have ended. That's important. Jumping to section 2, member states shall also ensure that competent judicial authorities may, on duly reasoned application by a party, take specific measures necessary to preserve the confidentiality of the trade secret, Jumping to the next paragraph, the measures shall include possibilities A, B, and C. C says of making available to any person other than those comprising a limited number of persons referred to in points A and B, a non-confidential version of any judicial decision in which the passages containing trade secrets have been removed or redacted, which is exactly what we're talking about. And of course, section 3, the competent judicial authorities shall take into account all the factors that are mentioned. Now that was the regulation, so that was the Trade Secrets Directive. They were implemented by various regulations. Again, I don't think we need to go to the regulations, although we've got them in the bundle. And importantly, Regulation 10 does faithfully implement Article 9, which is the important one. And then a short point I should perhaps clarify. Well, Justice Arnold says, for present purposes, the only provision of the regulation which is necessary to set out is Regulation 3, and then he sets out Regulation 3, and then at the top of paragraph 57, he says it's not necessary for purposes of appeals to consider in detail the effect of this curious provision. The judge at first instance thought the reference to curious provision was a reference to Regulation 10. In my summation, it's not. It's a reference to Regulation 3. There's no doubt cast by Lord Justice Arnold on Regulation 10, which corresponds to Article 9. And moving on in paragraph 57, after a lot more about Regulation 3, Lord Justice Arnold points this is unaffected by Brexit because the principle of supremacy of EU law continues to apply. The reference is given. And paragraph 58, it's common ground between the parties that the Trade Secrets Directive and the regulations are not directly applicable in the circumstances of the present case, because this is not a case in which there is any claim of unlawful acquisition, disclosure, or use of trade secrets. On the other hand, I do not understand either party to disagree the Trade Secrets Directive and the regulations inform the approach the court should adopt to the issues arising from both JCB's appeal and Manitou's appeal. A respectful submission is the same here, because the present case is about settling terms of a FRAND license, just as Bamford Manitou was about a patent infringement revocation action. Neither was directly about trade secrets. But my respectful submission, again, the Trade Secret Directives and the regulations should inform the approach. And I'm not saying that for the first time. I'm inviting the court to follow what Lord Justice Arnold has said about that. Now that dealt with the law in terms of how it was applied. If the court goes now to paragraph 71, page 427, open justice is a fundamental principle of English law. In the landmark case of Scotland, the House of Lords held that the High Court had no power, even with the consent of the parties, to order that a petition for the annulment of a marriage be heard in camera, or as we now say, in private, in the interest of public decency. And the rationale was given by Lord Shaw and Ferman, we see that, and then we have more about open justice in paras 72, 3, 4, and so on. However, there is an exception, and the exception, the relevant exception, is identified in Scott itself. So you can pick it up at para 76. Now, we've had all these authorities cited in favour of open justice, including Mohammed, we'll see at the top of this page. But the exceptions come out of Scott itself. And one of the exceptions, if I want to look at H, the other case referred to, that of litigation as to a secret process, where the effect of publicity would be to destroy the subject matter, illustrates a class which stands on a different footing. there it may well be that justice could not be done at all, it had to be done in public. And then as the paramount object must always be to do justice, the general rule is publicity, after all, when it means to an end, must accordingly yield. Now, the reference here is to a secret process, but as Lord Justice Arnold points out in 77, the other lords all referred more generally to trade secrets, and we would say that's entirely correct. The key point is not that it's a process, it's that the effect of publicity would be to destroy the subject matter of the secret. And we were very grateful to the court for sending us the monograph by Sir Nicholas Mostyn. Most of that, of course, is about family courts and other such matters. But it does, the monograph at page 21 does expressly refer to the trade secrets exception, is what we consider here. And in fact, the monograph at page 21 actually has a little bit more from Lord Shaw as to what a trade secret might be. And Lord Shaw talked about secret processes, inventions, documents, and the like. But the precise details don't matter, in my submission. The point is simply that whatever trade secrets are, they are things which must not be published, because then you destroy the subject matter thereof.
But for present purposes, the unpack rates, however they're expressed, whether they're lump sum or ad valorem, are trade secrets.
Correct.
The commercial trade secrets rather than technical trade secrets, but it doesn't really matter.
Yes. Again,
they're clearly trade secrets.
Yes. Again, my lords jumped ahead of me, but we say, well, they simply are. The judge held that the lump sum rates were.
Well, I don't understand that. Because if the one way of it, I mean, they're just different ways of calculating the figures, aren't they? Really? I mean, one's calculate one way, one's calculate the other way.
Yes.
If you've got one of them and you know enough, you can work out the other one, and vice versa. So if one of them is protected, it just seems to me the other one must be as well.
Well, my lord,
I just have a simple view of these things.
Well, I was jumping ahead, and,
Sorry.
and I was at one point going to say it's as simple as that, and that would be consistent with the previous first instance decisions. It's quite an easy answer. And of course, the judge held the lump sum payments were trade secrets, so why not the unpack? Well, in any event, I'll press on
Sure.
with this, and then we can put this away. Now, this paragraph 77, Lord Justice Arnold points out last sentence, subsequent jurisprudence distinguishing trade secrets and lower grade confidential information in the employment context. In my judgment, the same distinction applies in this context. He's actually not talking about the Trade Secrets Directive, but in any event, we'll see what he does in a moment. Now, paragraph 78, I don't have to read this out. This is a variety of ways in which the courts in this country do take steps to protect the confidentiality of the claimant's information. The last sentence is important by submission. The result is that English civil procedure has long complied with what is now required by Article 9 of the Trade Secrets Directive and Regulation 10 of the regulations. We're not being required to do anything different from what we've always done. Now, 79 is important because the third exception, as he says, was claims by claimants, but has long been recognised the same principle can apply to proceedings which the party seeking to protect its trade secret is the defendant, because that was Bamford itself. But of course, my clients were neither. We were dragged into it, but the same principle must apply to us, indeed at par 40 order. That point about defendants appears in 81. Now, long section, I don't think we need to spend much time on. Jump ahead to the passage dealing with the application of these principles in the instant case. And that starts at para 105 on page 437. So the starting point in Bamford is still the open justice principle. Skipping ahead, 107 doesn't matter Manitou of the defendants, and I would say it doesn't matter we're not parties at all. 108, the crucial point of the judgment is the correct characterisation of Manitou's claim. Now, respectful submission, what Lord Justice Arnold must mean here is the claim to keep the information confidential pursuant to Part 3122(2). You can't mean the substantive claim of the action, because that was a patent infringement claim. And then Para 109, again accepting the relative confidentiality of documents revealing criterion X are not high, but it doesn't stand alone. And then Para 110, we then go back to Scott and Scott. And where it's necessary to protect trade secrets, however, open justice must give way to a still greater principle, which is justice itself. The court is not engaged in exercise of trying to balance immeasurables. And the court accepts that G, just below G, this may make it impossible for the public to understand the details of the court's reasoning, but that is the price that must be paid for proper protection of trade secrets. This approach is well established in English law, but it agrees support from recitals 24 and 25 and Article 9 of the Trade Secrets Directive, and in particular 9.2c, which has been implemented by Regulation 10.5c. And I've drawn my last attention to all these things. And finally, over the page 110, last sentence, even lower grade confidential information is entitled to protection where its publication is not necessary for open justice. Now, is there anything in Sir Nicholas Mostyn's monograph which calls any of this into question? I respectfully say no. Now, if we return to the judgment under appeal to see how the first instance judgment dealt with that. Now, that will be Core Bundle 12. And if I want to go to paragraph 36, most of this is material we've already shown my laws. In para 38, for instance, towards the end, as Lord Justice Arnold observed, giving a judgment that the President of the Family and Lady Justice Elizabeth Lang concurred, the issues raised by this case involve Manitou's private interest in protecting its allegedly confidential information and the public interest in open justice. That is precisely the question which arises here. Yes, it is. Paragraph 39, this is where the judge says it's unnecessary for me to consider whether this curious provision, as Lord Justice Arnold termed Article 9. As I pointed out a moment ago, no, it wasn't Article 9 that was said to be the curious provision. And somewhat oddly, the discussion of Regulation 3 is then cut and pasted into the judgment. But then moving on, again, I don't need to read all this out because it's material that I've already drawn to the court's attention. In paragraph 42, the judge refers to the process described by Lord Justice Arnold in paragraph 77. I think it's actually paragraph 78 the judge means, but it was the same process that happened in this case. What's important in paragraph 42 of this judgment is the emphasis placed on paragraph 110, which is the same section I read to my lords. Now, going on to the judge's reasoning in 43, he says the case before the court will clearly concern trade secrets in the sense of process information, whereas, as Mr. Just Birss noted, Unwired Planet publication would destroy the subject matter of the proceedings, which is clearly not the case here. Now, that which is clearly not the case here, we respectfully say that's not correct, because, I mean, the subject matter of the proceedings in Bamford was patent infringement. It wasn't breach of confidence at all. But the trade secret in Bamford was criterion X, and publication thereof would destroy confidence in criterion X, which is exactly the same as we have in this case. It's all about the lump sum payments and the unpacked royalty rates. So it may not destroy the subject matter of the proceedings if you view the proceedings in this case as being settling a FRAND license, but it would destroy the subject matter of the confidential information, particularly the trade secret. So we've respectfully challenged that end of that third line there. But then it goes on to say, the Court of Appeal's judgment in Bamford ties into evaluative process that must undertake the definition of trade secret contained in the directive, which is far wider than the definition used by Miss Justice Birss and Unwired Planet. The only reason given for thinking it's far wider, given by the judge, is the distinction between trade secrets and lower grade information.
Can I just ask you about that first sentence?
Yes.
You're drawing a distinction between destroying the subject matter of the proceedings, which is not the case here, because the proceedings is a Fram dispute.
Yes.
And you're transposing that to destroy the subject matter of the secret, effectively.
Yes.
But any confidential information will be destroyed by publication. Does
That's
it not go a
true.
bit far, that submission then?
Well, it was exactly the same thing as happened in Bamford and Manitou, wasn't it? So I'm not saying anything different to what was said there. I don't see any rational way in which you can distinguish this case from that. I'm accepting my law's point. You know, publication of the secret destroys the secret. Yes, absolutely. There's no way around that one.
So the trade secrets directive is, or regulations are giving a heightened importance or protection to a secret, a piece of confidential information, if it's a trade secret. So if it arises in the context of trade, is that?
If it fits the definition in Article 2, which is the three-part
It's
definition.
very wide, isn't it?
Yes, but well, it's got to be secret. The second one might be the important one. It's got to have value because it's secret. And I mean, well, how valuable is valuable? Does that include things that are not terribly valuable, insubstantial value? At any rate, it's got to be valuable. So I think that's a filter. It wouldn't protect trivial information, but clearly it's enough to protect the criterion X information in the Bamford case, even though that was only saving people, you know, days or weeks rather than months. Anyway, what the judge does here is he applies the definition that I've just discussed with Lord Justice Zacaroli in relation to lump sum rates, and it satisfies each limit of the test. Material is in its precise configuration, by which he means the lump sum rate, secret in the sense defined in lim A, yes. This material has commercial value because it is secret, yes. And importantly, the judge accepts the class material would, if disclosed, give a negotiating advantage to any counterparty with whom a third party or Apple was seeking to negotiate a Fram license. So he's accepted all that evidence to get to this conclusion. Mm. And the class 3 material has quite obviously been the subject of considerable steps to maintain its secrecy. That's true too. So the lump sum rate's very easily passed this three-part test. But one can see from paragraph 44, the judge seems to be rather reluctant to follow Bamford. And one can detect the reluctance, perhaps from the third line. It's quite clear from what Lord Justice Arnold said in Bamford regarding the regulations that such a balancing exercise is not permissible now. That's the Unwired Planet balancing exercise. Where a trade secret is defined, the regulations in play, open justice takes second place. Do not consider such a balancing approach as open to me, given the manner in which 110, the Court of Appeal's judgment is framed by specific reference to the directive and so the regulation. Furthermore, to define trade secret by reference to a definition other than that contained in the regulations, in other words, to narrow that definition, to bring it more into line with what Mr. Justice Birss and the House Laws of Scott and Scott regard as a trade secret, would be impermissible to rewrite judicially that which the legislature has enacted and the Court of Appeal has stated as the law. So what do we get from this? Well, there's obviously reluctance. One sees that. The judge doesn't spell out precisely what he means by narrowing the definition in the fourth line up from the bottom, or why narrowing the definition in some unspecified way would mean the lump sum payments cease to qualify as trade secrets at all. I mean, how narrowly would you have to draw it to find that the lump sum payments aren't secrets anymore? But at least the conclusion is that the lump sum rates were to be redacted in the judge's view of Bamford. And at no point does the judge say, well, the lump sum rates are, quote, very dated. I pick these words because that was his first reason for declining to redact the unpacked rates. And we'll get to that at Paris 31.
Yeah.
We don't need to look at section D of the judgment.
Do you say paragraph 44 is right in a legal sense? Do you the sentence where a trade secret is in play, open justice takes second place, I don't consider the balancing approach is open to me. Is that right or wrong in your submission?
No, we would say that's right, because that's, I mean, the Court of Appeal has held that to be the position. Lord Justice Arnold and the other two judges agreed. So unless this court were to say, well, that's impairing curia for some reason, then it would be binding on this court as well, and it would require a higher court still to reverse it. Lords, would that be a convenient moment to break for transcribers?
That's really the effect of paragraph 110 of Lord Justice Arnold's judgment, isn't it?
Yes. 110, yes.
Effectively saying, well, I mean, where he says about the court is not engaged in an exercise of trying to balance incommensurables, which is the point I think that Mr. Justice Marcus Smith had in mind when he talks about the balancing approach from Unwired Planet.
Correct.
It's really overtaken by the Bamford approach.
Yes.
Under the regulation.
Absolutely. And my respectful submission, it's all explained very clearly, as my Lord says, in para 110, the left page of this. Now, my Lord, I was going to go on, but I've had a note suggesting a transcriber break as it is being transcribed. Shall I press on, or shall we have a short break?
Yeah. Okay. Sometimes we don't have breaks in the transcribers. Well, it's a relatively short case, but probably be sensible to have. Can we get back here, please, within 5 minutes? So on that clock, which is, I think, slightly fast. Just after 10:02 would be great. Okay.
Court rise in favour. Can I please remind the quorum that the live stream is still running?
Thanks.
Can you feel it? Like it's right on there. I'm trying to find the update. I can't find it. That's true.
When are you using it to update?
I think it was like today.
So it just automatically shuts off.
I think because I didn't do it, everything's crashing. Look at my app.
But I mean, how are you meant to do it though? Doesn't it do it itself?
No, I think there was like there was instructions on how to do it, but
Oh god. That's why your Teams is even working.
I'm gonna have to call IT. Do that though. Oh, it's cold.
Is it warm outside?
It was very warm. It's nice outside. I'm gonna go after the combat.
Actually, should I go at 12:30 so that I can go and do that? Do you want to get food? You don't want to go. Do you want to get food as well? I'll wait for you, then we'll just go out.
I can just have the later one.
Sure.
There's one plastic there.
Yeah.
I felt sorry for my head last time.
Yeah, it's not just a.
But I mean, you know, in reality, lots of
That's nice. Is it was Trial B, wasn't it? Straight after COVID.
Yes. We all had our masks on.
Miss Chili.
he's gonna send the J's.
Yeah, that's right.
We've got another.
I don't.
Court, rise if able.
Yes, Mr.
In other words, if I could take my lords on to the judge's class 5, which would bring us to the unpacked rates. That begins at para 52 on page 461. Now, para 52, the judge does accept the principle that if the lump sum rate could be reverse engineered from what he called workings, then the workings should be redacted to avoid undermining the effect of redacting the lump sum rate. So the judge does accept that. And if one turns to the next page in 53, the judge did accept that there would be an undermining effect as regards the content of table 12 and in the context of table 13. However, he said that the totals and overall averages at the end of table 13 can safely be disclosed. Now, it's not part of my appeal as such, but counsel for Apple and Optis and their schedule have pointed out there's two issues with that, meaning the totals and overall averages at the end of table 13. Now, I should show my lords what table 13 looks like for this purpose, but I won't read any of it out. I'm sure my lords have seen table 13.
Core bundle.
Yes, core bundle, tab 10, page 404. Just to show what my lords what it looks like, 404 over to page 405. And we see yellow, the judge has ordered redaction. There's no appeal against columns 2 to 6, but there's an issue on the totals and averages. Now, the 2 points raised by Apple Optis. One is a Qualcomm specific figure. I think Ms. Abraham will address my lords on that. But there's also a point about consistency. The court may wish to consider the treatment of these totals and averages for consistency with its approach to totals and averages in Table 10, where a similar point arises. Now, I accept that while the totals and averages do use my client's confidential information, it's somewhat indirect derivation because they use all the other entries in the table as well. And all I will say is that I respectfully support the Appellant suggestion that if the court is reenacting totals and averages for Table 10, the court should do the same for Table 13 as well, because it would be the same logic. But that's not a matter I'm going to say any more about, because it's not my appeal.
In some ways, see, it's not your you haven't appealed.
No.
I mean, you knew these averages were there.
Yes.
And you haven't appealed.
Correct.
Well, yeah, and there's no respondent's notice from anybody.
Correct. It's a point made by Appellant and Optis.
Not entirely clear what the status is. It's something that isn't before this court. I mean, somebody wanted to raise this point, they could have raised it. You could amend your notice of appeal if there's no complaints about it, which there wouldn't be. But otherwise, it's not before the court, is it?
Well, if there's no respondent's notice, that must be right.
I mean, we can't, as it were, fiddle with the judge's judgment in circumstances where nobody's actually appealing the relevant part of it.
Yes, I understand that. I'm not going to say any more about that. It was something that came up yesterday, and we support it.
Anybody else says about it?
Right.
Once you get on with it. Right.
Yes. Now, coming on to 53.2.
Yep.
Now, if my lords have the substantive judgment still open, I'll just show my lords what these tables look like, although I'm sure my lords are familiar. And again, I won't read anything out. If my lords go to Core Bundle tab 10, at page 386, that's what Table 9 looks like. And I can see the InterDigital and Nokia figures, but no one else sees, apart from the four at the bottom. I don't think objected anyway. So that's what it looks like, and that's the ad valorem rates. And then Table 10 is on pages 387 to 388. And again, I'll just show my lords what it looks like. And the relationship between Table 10 and Table 9 is Table 10 takes the Table 9 figures and prorates them so they're directly comparable. Just to explain in principle how that might work. If licensor X charges $10 for its FRAND license and licensor Y charges $8, it's not as simple as saying that, well, one's charging more than the other for that reason alone, because licensor X's patents might amount for 5% of the total stack of patents. So licensor X is charging $2 for each 1% share. And suppose licensor Y's patents amount for 2% of the total stack. Licensor Y is thereby charging $4 for each 1% share of the stack. And the details don't matter, other than you can derive tables 9 and 10. If you've only got one of them, you can derive it from the other. So they must stand or fall together in my submission. All you need to know is the licensor's share of the stack, which is otherwise available in the judgment. So having shown the Lord what these tables actually look like, then coming back to the actual judgment under appeal.
Yeah.
And that's Core Bundle 12, page 462, exactly where we were a moment ago. And in paragraph 53.2, the judge's reason for refusing to redact the unpack rates is all tied to what he saw as the possibility of reverse engineering. And he says, I do not consider that there's any real risk of these unpack rates being used to derive the lump sum figures contained in the Apple comparables of Google 2020 Optis license. And then he elaborates in various subparagraphs to this, beginning right with subpart A, as the judgment describes unpacking as a subjective and unreliable process, and I've already addressed my lords on, well, it couldn't have been that unreliable if it justified half a billion. But what is obvious from 53.2, if one looks through it, is that at no point does the judge ask himself the same question as he previously asked himself in relation to the lump sum rates. In paragraph 43, he never says, are they secret? Do they have commercial value because they are secret? And have they been subject to reasonable steps under the circumstances to keep them secret? And instead he seems to regard the only relevant question as being, as I say, ease and reliability of reverse engineering. I've drawn attention to 53.2a, but it's essentially the same point made in all of these subparagraphs, A to E. In 53.2d, for instance, the judge dismisses the importance of the fact that Mr. Besant's data had been published. It was,
What would you reference, Mr. Campbell?
it's 53, well, if one looks at 53c, third line, Mr. Besant's data had in fact been published and was openly available. And then 53d, it seems to be, given the other points made above, even so any attempt to take back bearings would
Being
result
very
in...
stupid, I'm sure, but I don't have a 53C.
Oh, sorry, 53.2c,
Page 463.
page 463.
Yes, thank you.
Is my lord there now?
Yep.
I'm grateful. And the point is about, can you reverse engineer it? The judge throws down a challenge. Oh, I don't think you can because Mr. Besant's data has not been published. C, actually it has been published. But even so, the judge says any attempt to take back bearings or outcomes so unreliable as to be entirely useless. And then he's gone in some detail about why says that. I'll come back to this reasoning in a minute, but at the moment we're just looking about the principle of the thing. And if one goes to 53.2e, sorry, 53.3, he says, final sentence, I do not accept that an inaccurate re-engineering of unpacked rates can be regarded as confidential information. And that implies that an accurate re-engineering would be so regarded. But as I've said, he hasn't asked himself the same three questions as he did for the lump sums. If he had, what would the answers have been? Are the unpacked rates confidential? Yes, my solution, of course they are. It's just another way of expressing the lump sum payment information, which is unquestionably both valuable and confidential, as the judge himself held. And it was merely intended by Mr. Besant to represent the dollar per unit equivalent of the same information. So why should it have lost any degree of confidentiality just by being converted from one means of expression into another? And that was my Lord the Chancellor's point. It still is useful information, it always was. And secondly, do the unpacked rates have commercial value because they are secret? Well, absolutely. It's the same points as is stressed in the evidence, Mr. Earle, Ms. Mattis, Mr. Very, Mr. Ridgway, Ms. Muse. It's of substantial commercial value to a would-be licensee seeking to obtain an asymmetrical advantage in negotiations with relevant licensor. And thirdly, whether
The judge seems to be driven in this part of his judgment by his view that repacking, if I can put it that way, was not really, either wasn't possible, or it would have been an entirely inaccurate process. And your point is that's just neither here nor there, because whether it's ad valorem or lump sum, it's all confidential information and falls within the three criteria.
Yes, correct.
Quite apart from the fact you challenged the conclusion that the judge's conclusion, which seems to be contrary to the evidence, that you couldn't repack or unpack one way or the other.
Yes, my Lord has it. Yeah. I mean, there's an extra submission we make on top of that, but we say that those answers, my Lord has just indicated, are sufficient for the appeal to succeed. The extra point is, was the judge right to find that confidentiality depended on the ease of reverse engineering anyway? and this is InterDigital's ground 5 and Nokia's ground 4. And I'll deal with that now, just to say that's wrong as well, but it's an extra point on top. Essentially, there's 2 points about this. One is, was the judge factually correct about the ease of reverse engineering as he's expressed himself in C and D? I touched on that a moment ago. The point in 53.2c, page 463, as I just said, Mr. Bazant's data had been published and was publicly available. And then the point in 53.2d is the judge, he gave a challenge to the parties. Well, can you show how reverse engineering might be done using the information of the judgment? And that was because of his extreme skepticism about this. And he was given a worked example as he sets in D. But even so, that's still not enough for the reasons given in 53.2d, Roman 1 to 3. The judge appears to be satisfied that it would be possible to perform the repacking exercise, but he just regards the risk of being wrong as being very high. And he says that for the reasons set out at subparas 1 to 3. It's not clear with respect how the judge reached his view the risk was, quote, very high. Because you've got 4 steps in 3. You've got to have someone who's mathematically capable, there are plenty such people, a deep knowledge of the judgment, and all you've got to do is read it. Knows the location of and can obtain the material that's not mentioned in the judgment. Well, that's Mr. Bazant's data, which has all been published. So why is the risk of being wrong and not checkably so very high on the basis of that material? But secondly, and this is a distinct ground of appeal, we say that even this is all true, why does that matter? We say that the unpacked rates are still my client's confidential information, should still be protected. And the analogy we drew here is with quite a different field, protection of factually inaccurate information in the context of law on privacy, which was personal privacy. Now, that's a different area of law, but before going to it, the unpacked rates were generated by experienced forensic accountancy experts, probably quite a large team of people, highly experienced solicitors using their best endeavours for purpose of court proceedings. So it's not inherently likely to be inaccurate, although of course it may be. It's not like a newspaper journalist trying to catch a deadline in a hurry. But just disregarding that, suppose the unpacked rates are inaccurate in the sense they only give an imperfect guide. In my submission, that's not a fair question, because there's no such thing as, quote, accurate unpacked right in the first place, for the reasons explained by Lord Justice Birss. There must be some subjectivity. The purpose is they're useful, and that's all that matters. And even inaccurate information could still be used in negotiations. It still creates the information asymmetry, particularly if it has the authority of appearing in a court judgment. Now, my Lord, on the personal privacy cases, I did refer to 2 authorities. I was going to take my Lord to these now. I'll try and be brief about it. The first is McKennett and Ash, and that's joint authorities at tab 9. Tab 9, page 534. One can pick up the nature of the case from the head notes, first few lines. Claimant was a renowned musician who sold millions of recordings worldwide, carefully regarding personal privacy. The defendant had been a close friend, then wrote a book of the claimant containing personal and private information about her. And then at E, it depended on balancing the claimant's right under Article 8, the European Convention, to the defendant's right to freedom of expression under Article 10, which is a different factual scenario to that certainly. But pick it up at paragraph 78 on page 561. This was a point made by Mr. Price, who was he's the solicitor for the defendant. And the submission that he made in this case is there could be no claim in breach of confidence because the relevant allegations were untrue. One gets that from the second and third lines of para 78. And we see Lord Justice Buxton deals with this on para 79 and 80. 79 would not reflect well-known law if that plea would succeed. Yes. I take the rest of this paragraph as read. Para 80. That, however, is not this case. I would hold, provided the matter complained of by its nature is such as to attract long breach of confidence, the defendant cannot deprive the claimant of his Article 8 protection simply by demonstrating the matter is untrue. I don't need the rest of that. And Lord Justice Latham agrees with that at 82, and Lord Justice Longmore adds a little bit of para 85. Same point about does the alleged falsity make any difference? Over page para 86. This argument, in my judgment, is untenable. The question in a case of misuse of private information is whether the information is private, not whether it's true or false. The truth or falsity of the information is an irrelevant inquiry. I don't need the rest of that. So what I get from this is the test in that context is whether the information is confidential and not whether it's true or false. And there's another case in the bundles making the same point, which is Campbell and Mirror Group newspapers, but we don't need to go to that. Now, obviously, these were cases about personal private information, not commercial secrets. But why my submission, should the logic be any different? The origin of the unpacked rates was my client's lump sum paid under the license, and that was their confidential information. And the assumed inaccurate...
Logically the same analysis
Logically the
should
same
apply.
analysis, absolutely. My lord's got it. Now, I'll just say, but I don't need to take the words to it. There was actually a dispute in the case between Mr. Bezant for Optis and Apple's expert, Ms. Gutteridge, as to the correct form of unpacking. And as my Lord Justice Birss noticed, there was this discrepancy, particularly as regards Ericsson. But that didn't mean that the court ignored one expert's figures in favour of the other. It used them both, even though one of them was perhaps, well, they were different. So one might have thought that perhaps one was more accurate than the other. At any rate, for all of these reasons, respectfully say the judge should have redacted the unpacked rates in tables 9 and 10 following Bamford, just as he redacted the actual lump sum payments. Before moving on, just 3 final points on this. If my lords go to paragraph 35 of the judgment under appeal, just before he deals with Bamford, but he explains in advance what he's going to do. It's Justice Marcus Smith, he's dismissed the argument based on a balancing exercise in Unwired Planet. And then goes on to say, however, due to a recent development of the law arising out of the decision of the Court of Appeal handed down since the decisions of Justice Birss, Mr. Unwired Planet Digital, I am obliged to reach a conclusion that results in rather greater redaction than either Mr. Justice Birss and Mr. Justice Miller ordered, and which goes beyond what I've decided on the basis of the old law. With respect, that characterisation is not correct, because both Mr. Justice Miller and Mr. Justice Birss redacted unpacked rates as well as actual sum payments. There's one small exception, the case of InterDigital. There was a RIM 2012 licence, I'll say something about it, but that small exception apart, unpacked rates and lump sum payments were redacted. So the judge's conclusion actually results in rather less redaction than either Mr. Justice Birss or Mr. Justice Miller, not rather more, or rather greater redaction, as he appears to have thought in 35. And then finally, there's 2 points arising out of the Apple Optis joint note. The first is whether there should be consistency between the appellants and non-appellants. I'll just say we don't hold a brief for the non-appellants, but we don't oppose that. And the second was the tables and averages point on table 10, but I don't propose to say any more on that.
Okay, well, just putting those 2 points together, I don't want it to be missed, if I may put it this way. In a large table of numbers, many of which are not numbers that any appellant before this court is asking to be redacted, but you're one of them, you want us to redact it. At the bottom of it there's an average or a total. There is a rather mathematical inevitability about the fact that when you don't redact lots of the numbers in the table and not the total, neither of which you have asked us to do in your appeal, that might be said to have an effect. And I just want to make sure that I wanted to say that to you because it's clear to me, as far as I can see, that you're not asking us to do that. You haven't appealed, and you know, if I can put it this way, rather crudely, don't come crying to me when you say, hang on a minute, this piece of information which we think is terribly important is sort of maybe possibly something that people could figure out, not directly and not exactly, but
Yes.
so I just think it's important that we just be absolutely clear what, as I understand, what this court's being asked to do is.
Yes, and I think the clearest answer I can give, if my lord goes to Core Bundle 10, page 387, and sees Table 9, for instance. It's certainly true that I'm asking for my client's information to be redacted.
Yes.
Page
387.
387.
Yes.
So I'm asking for both of my clients, that's Nokia and InterDigital, to be redacted. We also have the other represented parties.
Yes.
So we've got Qualcomm, we've got LG, we've got Google, we've got Huawei, and they're all actually asking for that.
It's about 6.
That's 6.
Out of about 20-ish. I don't
True.
know.
So what the point raised by Appellant Office, which we didn't really focus on until yesterday, because we only have a look at our little bit of the table, is what to do about the other people who have been redacted. And there are two categories. Most of these people, I mean, to take CG 2017 for instance, they've been redacted. Now I'm not
CG 27.
CGE 2017, top of page 388. I just picked that one at random.
Oh, yeah. CC.
Oh, sorry, CCE, yes.
Right, CCE, yes. Okay, yes,
Yeah.
I don't even know who they are, but take them, yes.
Yeah, take them, or any of the others.
Well, they've been redacted in the same way that you've been redacted, which means they won't be redacted.
Yes, well, I don't hold a brief for them.
No, I understand.
Now I understand, and we really haven't focused on the consequence of the rest of the table because we've never been to see the rest of the table. But we certainly would support the redaction of that for the same reasons as my lord just indicated, because it makes it easier to backwards work out what we are. What I can't say that about is the people who are on Claire at the moment, as it were, because they made it clear they didn't object in the first place.
So CCE aren't before this court, are they? They're not one of the appellants.
No, they're not one of the appellants before this court, and that's true.
So the judge's order says, the judge's order doesn't say these words, but the effect of the judge's order is that the entry for CCE, the numbers there, will not be redacted when the judgment, when this process is finished. And it might be said, you've always known that, and you haven't appealed the judge's decision to not redact. I know it's redacted at the moment, but that's the whole point of this. The whole reason we're all here is that that one, for example, and your equivalent isn't redacted.
Yes.
Isn't going to be redacted.
Yes, I follow that. My understanding, and this may be wrong, my understanding is all the ones that are redacted are people who objected in some way, shape or form at first instance.
I don't know if that's true or not.
Okay, I'll check and see if that's right. I do know that people who, Cyrus for instance, and Doro and Blue, they were quite relaxed about it, that's why.
Right.
I'll check and see what the actual status is. But the short
I'm not
answer...
sure why it matters whether somebody did or didn't. Let's take, take CCE. The CCE, I mean, it may be that part of the problem with this is that you weren't aware of all this, but the CCE number on because I've got all the numbers, we've got all the numbers sitting here. But the CCE number is the same colour as your number, which is blue.
Yes.
On our screen. And what blue means is that if the judge's order stands, these numbers will not be redacted. And CCE is not before this court. As far as I know, CCE didn't make any submissions at a hearing at any rate before the judge, but whether they did or didn't, even if they did, even if they asked the court to not do it and the judge didn't know, the judge didn't do it, and they haven't appealed. No one before this court has asked us to overturn that decision until we're now having this conversation.
Yes. Yes, the short answer is we just didn't have visibility of how much else what was. I mean, this is something that Apple and Optis have always had visibility of, and we just haven't. We've only ever looked at our position at the table. I know that's not an answer. That's actually why we haven't, just pick CC, the same point applies to other
Yes, well, there's about 20 numbers on this table, and this is the point I'm putting to you, which is why I'm glad I did now. So there's about 20 numbers in this table. You're only asking us to redact 2 of them, because you have 2 clients, and you also haven't appealed, and it was apparent on the face of the table that there was a total at the bottom.
Yes, we didn't appeal the total, that's certainly true.
But the consequence, it seems to me, of the totals, plus, I mean, I don't know if, mathematically, because there's more than one variable, maybe you can't actually work it out in a precise way, but the fact that there's a relationship is apparent, and it's not been raised, so why should we do anything about it?
Well, I follow the question, and I can't say it's part of my appeal, because it just isn't. All I can say is, when I saw the note from Apple and Optis, we decided to support it for exactly that reason. But I appreciate that's not an answer to my law's point.
I mean, in this table, page 387, 388, the parties who are appealing in bold, aren't they, on the left-hand side? Nobody else is appealing.
You probably haven't even got the same version that my lord.
I don't have bold, no.
We have a version which has got your names written down on the left-hand side. So beside the Huawei one, it says Huawei, and that's in bold because Huawei are appealing.
InterDigital's in bold, etc.
Yeah, they're the appellants.
Yeah.
Yes, I don't have the
As
bold
my lord
version.
says, there's about 20 odd in all. I haven't counted them up, but it looks like that. Only 6 of them were. And as my lord says, there's some totals as well.
Well, that's other questions, but these are the only answers I can give.
Just a moment.
Sorry, we could just take a moment to
Yes.
take some instruction. Yes. Well, I think the only point to make is that my lord is right that we did see these redactions in the judgment, which was supplied to us. But my clients, both of them, have had the problem of not being able to see the whole picture. It's been a consistent problem they've always had. So it certainly wasn't obvious to me that all the ones in black were going to be published. Perhaps I should have appreciated that. My understanding was just that the ones which are, as I say, en clair were going to be published. And that's where we are in any event. I appreciate that's not an answer, that's just where we are. Yeah.
I'm not trying to encourage you one way or the other, Mr. Campbell, but I mean, if you're...
The point that troubles me, and I think troubles my lord as well, probably troubles all of us, is that if the totals remain, as they are in our copy, you can see how somebody could work out at least what the average was of the people who've been redacted from the totals and from the people who haven't been redacted. You wouldn't need to be a rocket scientist to get to a fairly
Yes, I follow that.
a fairly accurate, despite what the judge said, a fairly accurate figure for each of the appellants.
And it's for those reasons we'd like to resist that.
It might be said that total redaction is what's required, but that's not what we're being asked to do. And, explained our concern.
Yes, I see that. If it were at all open to me, I would ask for the totals and all the other redactions to remain precisely for that undermining effect. But I appreciate we are where we are for that. Well, that's Bamford at any rate.
What's the position, picking up on that point, if something that isn't, let's assume in your favour your figures are confidential, but the appellant's figures are confidential. But there are other figures there which, in relation to which it's not your confidential information, the totals. But the disclosure of those would affect your clients and might breach your confidential information. What's the position in terms of your ability to seek to redact everything?
Well, I haven't specifically appealed against that.
No. I mean, the problem, of course, is you haven't seen the figures, whereas we have. We fully understand that.
Yes.
Speaking entirely for myself, the position is that you're in a difficulty which you can fairly say to us, you can't be criticised for not having appreciated it until now, then I don't suppose the court would be particularly unwilling to help, as it were. But it does rather depend on whether that's true or not. If on the other hand you're in a difficulty of your own making, well then the court tends to be rather less sympathetic.
Well, it's certainly not, it's never been the position that we've been able to see the whole of the table. And even now we seem to have a slightly different version. All we've ever been able to see is the material which people consented to being published, and that's always been the position. And otherwise a whole series of blanks. And the blanks relate to everyone else's entry apart from us and the tables. Totals and averages at the bottom. We've never seen that. And if I'm not saying we should have been able to work out that that was going to be redacted, and there was, all I can say is what I said earlier, it wasn't actually until we saw Apple and Optis's note that we really focused on this at all. And that was a note which we got on Monday. It's very helpful of them to do that, because they've always been to see the entirety of it, as the court has always been able to see the entirety. And my clients just haven't.
So what you're explaining, I think, Mr. Campbell, if I've understood you correctly, is that you were never told that the status of the redactions, let us say, of the table of the totals, was what it in fact is, which is that it would become public if the part of the appeal succeeds.
Well, I don't think I can say that for table 13, because the judge actually said in terms that the totals in table 13 were going to be published. I assured my lords that a moment ago.
Right, this isn't table 13.
Yes, yes. Well, I want to give a correct answer to the question. And yes, under 53(1)(a), we were told that the totals and average overruns into tables 13 are going to be disclosed.
Yes.
I'm not aware we were ever told that about tables 9 and 10. Are we correct?
Focusing on table 13 for a second. At table 13, none of the data in the middle of the table, none of the actual numbers in that table are to be disclosed. They're all yellow,
Yes.
except for the totals. So that is a different thing from the situation in the other table, table 10, I think it was, where all the figures that are potentially redacted are blue.
Yes, I follow that, yeah.
And the point, as I understand it, the point is that you didn't know. You were only given an extract of the form of the judgment that was in the form annexed to your original order. And the extract doesn't show you what colour bits that you weren't given were.
Yes, that's absolutely true, yeah. We just had as I said, all we got was everything was redacted apart from the stuff which was never going to be redacted, and our own figures, we were allowed to see our own figures. as my Lord said, there's a difference between table 13 and 10 in that respect. Now that's Bamford approach. I was now going to deal with Unwired Planet, which is the balancing exercise. And again, I'll try and do this quickly. Unwired Planet is at Joint Authorities tab 12. Now, my Lords will have pre-read this, so try and go to the key points. First, as set out in the head note, don't need to read it out. The factual scenario was the same as the present case. There was an initial public judgment with redactions, and the issue considered in this judgment is what redaction should be retained in the final version. And the analysis begins at paragraph 7 on page 674. And don't need to read this out. It goes through all the principles, starting with justice should be done in public. It refers to the Mohammed case, which very frequently cited, and points out in 10, none of the information which I'm asked about is a technical trade secret. It's all information relating to licensing. So it's commercial licensing information. We see that description from the top of the next page. Now, paragraph 11, the judge, Lord Justice Birss, says, so I've not heard truly adversarial argument about the matter. And that's the subject. So we'll see the next one, InterDigital, there was some adversarial argument. Paragraph 13, Ericsson pointed out that the relevant sort of information, in other words, the license rates, the unpacked rates, is often redacted from judgments relating to competition law, so it's not an unusual thing to do. And then paragraph 14, the main point in paragraph 14 is really the last sentence of paragraph 14. Nevertheless, it strikes me the lack of public information about frowned license terms is a cause of difficulty in this sphere, and perhaps more transparency about royalty rates would be a good thing, but this is not the occasion to get into that. I'll come back to that. Of course, one of the problems, and this mentioned skeleton arguments, the problem about an ad hoc judicial process, whereby the royalty rates of whatever licenses happen to be in the instant case, happen to be important there, is that the burden of disclosure only falls on the parties whose license happen to be an issue. In oral argument, Mr. Justice Marcus Smith referred to the possibility that requiring disclosure would lead to, quotes, oiling the processes of FRAN negotiations generally. That was his word, oil. But of course it wouldn't. There are lots of licensors and licensees forming a large industry. So any judicial employ ad hoc oil would only apply to a very small cog, depending on whatever happened to surface in the particular case. Now, moving on to the factors, they are set out in paragraphs 22 through to 24. And I'm not going to read this out because my lords would have read that. I would stress the fourth line of paragraph 23, just following the statement, redactions will require powerful reasons supported by cogent evidence to address the details, and generalities will not do. Now, it is absolutely true that generalities will not do, but we respectfully submit that remark needs to be understood in context, because the party seeking redaction would at least have to identify the information sought to be protected with precision and why. But it doesn't follow the party seeking redaction has to identify who specifically is likely to use the confidential information. Because in most cases you won't be able to be more precise than saying future potential licensees in future licensing negotiations. I mean, even the identity of licensees are currently in negotiations is normally the subject of NDAs. And then, so far as the facts of Unwired Planet are concerned, there's only one point to which I would seek to draw the court's attention, and that's at paragraph 41 on page 680. And it says here, paragraphs 41, 44, 45, and so on relate to details of the 2009 Ericsson Huawei license. I have accepted proposed redactions which were sought by both Ericsson and Huawei. These redactions remove the specific figures, but wider redactions were sought. So, and the wider redactions were not made because the license was signed in April 2009, expired in 2012, and the date of this judgment is 2017. Now that was 5 years previously, the expiry, but the figures were still redacted. It was merely the other terms which were not. And otherwise the details don't matter other than observing, and it doesn't emerge from this judgment, but it's obvious when one compares the pre and post versions of the substantive judgment, that the redactions were both the actual lump sum payments and the unpaid rates. In the case for Justice Marcus Smith, I did make that point by going through the pre and post judgment to show that. Now that completes Unwired Planet itself. It's also worth looking at the three of the judgments in InterDigital in Novo. The first of these in time is Joint Authorities Tab 3, and going to yes, and if I want to go to page 134 of the bundle, at paras 196 to 201, Mr. Justice Mellor analyses the ETSI guide on intellectual property rights, ETSI being the standard setting organisation. And he's highlighted various general statements. Now we've included the current versions of these ETSI materials in the sub-bundle at SB2, 27 and 28, but it's not necessary to go there because the key sections haven't changed. And this goes to the point made by Lord Justice Birss in paragraph 14 of Unwired Planet about the desirability of greater transparency in ETSI licensing. And the point is that ETSI itself doesn't require that. And one sees that from para 198, quote from section 4.1 of the ETSI guide. First, commercial issues shall not be addressed within ETSI for the reasons given. It would delay discussions. Roman 2 of 198, you can make some voluntary unilateral public ex-ante disclosures, but Roman 3 in the next page, there is no obligation on any member to disclose any licensing terms. And then quoting from sections 4.4 and 4.5, 4.4 is about the use of NDAs and IPR negotiations. To recognise that they may be used, and this general practice is not challenged, it says. Now, in next paragraph 200, section 4.4 says, Mr. Justice Mellor, is diplomatically worded. The widespread use of NDAs is not challenged, but the strain of the second sentence is evident. The second sentence is the one where ETSI expects its members, as well as non-ETSI members, to engage in impartial, honest, essential IPR licensing negotiation process for FRAND terms and conditions. So going back to 200, there's no doubt in my mind that SEP universe will be able to converge on agree FRAND terms very much more quickly if the basics of each set license were made public. By basics, I mean the number of units covered, royalty units, or total sum paid payable, and which standards are involved. In other words, the market for mobile telephony SEP licenses would work very much more smoothly with transparency of what terms we agreed in the past. However, it is apparent that for ETSI to require transparency was a step too far. Instead, there is the stated expectation that those who are subject to the ETSI undertaking should engage in an impartial, honest licensing negotiation process for FRAND terms and conditions. Now, the reason why it was a step too far to require transparency aren't difficult to understand. As the same judge observed later, and we'll see, virtually all players in the market seek to maintain confidentiality. The people most in favour of transparency are the would-be licensees who haven't yet signed any agreements with anyone, but as soon as such persons start signing patent licenses, they don't want their own financial information being shared with anyone else. So they've changed from being poachers to being gamekeepers. Second in time is the decision of Mr. Justice Mellor in the same case, and this was post-judgment. It was about redaction of third-party license information from his judgment.
Yeah.
And was it there? JAB tab 4.
Tab 4.
And again, I'll try and go quickly. Bottom of page 311, the judge notes 3 Roman 3, Lenovo submitted the principles of open justice required the court to take a quite different approach to that proposed by InterDigital and the third parties. Thus, it was Lenovo's contending a number of the redactions should be removed. So, unlike in Unwired Planet, there was adversarial argument from Lenovo this time around.
Yeah.
For section 1, the first category was confidential royalty rates and unpacked rates. They were put together. You'll see the judge treats them together, the royalty rates and the unpacked. 5.4a at the bottom of the page, a bit more about Lenovo saying that Unwired Planet should not be a bar to fresh consideration of the applicable principles, so that indicates some sort of adversarial argument. Para 7, though, we do see the relevant principles being set out. I don't need to read them all out because we've looked at them before. And in Para 10, I mentioned this earlier a moment ago, second sentence. As I have previously commented, the SEP licensing market would operate much more efficiently with a greater transparency. However, the reality must be recognised that virtually all the players in this market, whether licensor or licensees, seek to maintain confidentiality over their license terms, and particularly the financial terms. Must also be recognised that in order to decide this type of case, the court benefits from the assistance and cooperation of third parties, allowing their confidential information to be used, even when the court exercises its power to require or order disclosure from the parties. So even if greater transparency was a good thing, it's not for the court to develop a doctrine on an ad hoc basis. And the result on the facts we see from paragraph 42 on page 321. InterDigital's, as for InterDigital's category 1, it includes redaction of unpacked and actual and unpacked royalty rates from current or recently expired PLAs, including particularly the Lenovo 7. These data are more or less current. Now I can tell, my lords, the Lenovo 7, the oldest one of these was Samsung 2014. You don't need to go there. It's Paris 624 to 625, the substantive Fran judgment, Joint Authorities Bundle 3, page 237. And there was an exception for RIM 2012, I mentioned that earlier in para 44. The reason why the rates in RIM 2012 were not redacted was because on the facts they were just too old and too irrelevant. And one can go back to para 129 of the main judgment to see more detail. But in the main Fran judgment, Mr. Justice Mellor explained its irrelevance at para 712 to 716 and said, I do not propose to place any reliance on RIM 2012. And the main reason why it was irrelevant, apart from the age, appears in the last sentence of 44 of this judgment, even though 2 of the rates were 4G rates, 4G being important, they are largely irrelevant to any current 4G rates. So, performing the balancing exercise, there may be individual instances of things which fall on the wrong side, and this was one example. But in this case, my clients don't fall within that exception. And finally, in para 45, one point to add relating to the terms of RIM 2012, InterDigital pointed out that the 4GMM rate set out in 134 was wrong. I will therefore issue a corrected version of the confidential judgment, and the corrected figure will appear in the new version, the public judgment. That was done with very little fuss. We didn't have a 3-part test on that correction. And the concluding remarks in 51, my Lord the Chancellor already pointed this out. 51, I recognise significant costs have been incurred on confidentiality issues in these Fran proceedings by InterDigital licensees and other third-party providers. Last sentence, a lot of these costs cannot be avoided. but 52, last sentence, assuming my approach to confidentiality is either not challenged or is upheld, it is to be hoped that costs of this type of final confidentiality hearing can be considerably reduced in the future on the basis that the court can be expected to adopt a similar line to that set out in Unwired Planet in my judgments in these proceedings.
Rather like judicial comments of that kind in all sorts of different contexts, what tends to happen is the precise opposite.
Well,
Templeman's famous thing was saying that issues as to jurisdiction could be determined in the judge's room in 5 minutes or an hour or whatever it was. One thinks, looking back on that, things spent days and days on jurisdiction challenges, even in this court.
yes, I mean, yes, considerably more than the 4 hours, yes. That's all true, but I mean, respectful submission, the reason that didn't happen in this case is precisely because the judge didn't follow that approach.
No, I follow that.
Yeah.
But can I just stop you there? Because I thought, why are we looking at these cases? You say the judge was right to adopt the approach in Bamford, which is different. It has effected a change on your case.
Yes, that's my second ground of appeal. If I'm wrong on that, my first ground of appeal is on the existing law.
So which order do you put these in? What's your case? Are you saying the judge was right to apply Bamford and that's all we need to look at? And this is a fallback argument? Or how do you put it?
That is how I put it, yes. I said that is how I put it.
Right.
Okay.
That's why I started with Bamford.
So this is only relevant if you're wrong.
Correct.
That Bamford has changed everything.
Yes. In fact, I think I even said it may not be necessary for my lawyers to deal with these cases if you're with me on Bamford.
That's helpful.
Right.
Right, so that's the second Lenovo, and the third, sorry, the InterDigital. The third is the substantive appeal judgment, InterDigital and Lenovo, and the short point on that is all the royalty rates and were redacted and that, and no one's complained about that. Now, just to make that point a good one, if we go to page 323, we see the appeals heard in June, July 2024. And we can go to paragraph 48 on page 343. This just gives the dates of the Lenovo 7. We see the oldest is Samsung 2014. And if we go to paragraph 105, this is where this court analyses what it considers the judge's analysis of Lenovo 7, and we have all sorts of dates set out for them. The start and finish dates are all set out. And all I really get out from this is that, I mean, Samsung 2014, that was entered into on 1st June 2014, the effective date of 2013, running through to 31st December. So it's some date similarities, the ones in this case. But all of the derived rates are all redacted, and that's true for everything. And one doesn't need to spend too much time on it, but para 106, first line, that was redacted. 107, third last line, that was redacted. And 109, second last line, redacted. The point is quite simple, that this court redacted all the rates in all of these cases. Not on the basis of adversarial argument, that's true. But the court did at least redact the exact same things as I'm asking this court to redact. I'm not aware of any criticism on the part of the public that they've been unable to understand this judgment due to these unpacked rates not being disclosed. Now that's the cases. Now look at what the judge made of this. And for this, we need to go back to the judgment under appeal. Sorry, it's 12. Hold on, 12. Page 449. And here's where the judge, paragraph 30, he starts by setting out key paragraphs of Unwired Planet. And then he applies at para 31. 31.1, he begins with the confidentiality provisions in the PLAs, patent license agreements themselves. 31.2, he points out correctly that the third party didn't choose to become involved. That's correct too. And then class 3 material is, I accept, confidential. So that's accepted. But then, somewhat oddly in our submission, in paragraph 4 on page 451, he says that the class 3 material, that was the actual sums paid under these licenses, is not, in my judgment, especially commercially significant. And why was that? It is, as Annex 3 shows, quotes, very dated in a market that is both dynamic and developing. Now, the judge refers to Annex 3, so let's look at Annex 3. Again, we won't read anything out. But if the court goes to Core Bundle 10, at page 420, the court will at least see what Annex 3 looks like. So it includes a lot of start and finish dates. It's got the start and finish dates for my clients' licenses, for instance, the Nokia and InterDigital ones. I've already given my lords the dates of that. They expired on the 30th of September 2022 in the case of IDG and 1st of January 2024 in the case of Nokia. So in my respectful submission, that information wasn't, quote, very dated at all. It was very recent. And as I've also pointed out, this court used both the InterDigital and Nokia unpacked rates in its substantive judgment. And my respectful submission, the court would hardly have done so if that information was, quote, very dated, close quote. And furthermore, the judge had held that the same information, the class 3, that's the actual lump sums, he'd held it was trade secrets within the Article 2 definition explained in Bamford, which is difficult to square with it being, quotes, very dated and presumably not valuable at all. But just looking at the table itself, if my lords still have it open, it's not clear how this proves that the market is both, quotes, dynamic and developing. All it's showing is a whole lot of contracts with different start and finish dates. My lords will also recall the date of the judgment under appeal is February 2024, although the public form of the judge's judgment had been handed down on 10th May 2023 and oral argument in July 2023. So the oldest one of the judge's Annex 3 is indeed the one described as Huawei 2014 on page 420, which was extensible to 31st December 2019, as we will also see. Now, if time from signature is what matters, my submission is it doesn't. So you look at the period for which the license was in force. Was it still in force recently? Then Huawei 2014 wasn't any older than the position of the Samsung 2014 license, in relation to which this court maintained confidentiality in IDG and Lenovo. So even the oldest one in Annex 3 wasn't, quote, very dated, and the rest are all younger. And the judge notes that the earliest he calls Panasonic 2020. I think let's go to Annex 3. It's on page 425. That was dated 22nd December 2020, in fact, and it runs until 22nd of December 2025. That can't possibly be very dated, but it's still within the judge's description of very dated, so it's as far as we can see. The judge also says that most of the licenses in question are not current, their terms already expired. This is significant because renegotiations to the license will likely have already occurred. Now that's a very odd comment, because if the judge is talking about renegotiation between the same parties to the original license, they'll already know what the terms to the original license were, because they were the parties to it. But he's talking about new negotiations between the existing licensee and the new licensee. That's not a renegotiation at all. That's a fresh negotiation. And stand back and what's the net result of the judge's conclusion as set out in this paragraph? The judge hasn't redacted any actual license payments from any licenses under the old law, whereas under the new law, he had redacted the actual license payments for all of them. So at no point was age a factor in the judge's consideration. He just thought the old law wasn't good enough to redact anything, and the new law was good enough to redact everything. And the judge did have the evidence to support redaction. It's Mr. Elm, Ms. Mattis, Mr. Very, Mr. Ridgway, Mr. Muse, and no evidence the other way. And the judge's footnote 31, I received no evidence in relation to renegotiation. Well, he did have all the evidence saying it was confidential and valuable, which isn't addressed here. So this in our submission is a rather confused passage of the judgment. And in 31.4b, the next subparagraph, he says none of the third parties explains any granular detail the adverse consequences of disclosure. Mr. Justice Birss and Unwired Planet stressed that redactions will require powerful reasons supported by cogent evidence which addresses the details. Such evidence has not been forthcoming in the present case. As I've already said, it's difficult to see how much more granular the evidence could have been, but certainly the evidence before this judge was essentially the same as the evidence which had succeeded on this point before each Mr. Justice Mellor and Mr. Justice Birss. It always said the appellants all have licensing business, this is highly confidential material, and publication will damage that licensing business because of the asymmetric advantage it will give to the negotiating partners. And in C, the judge says this is not a case where disclosure of the Class 3 material will involve the disclosure of a trade secret, where publication would destroy the very subject matter of the secret. Well, why on earth not? That's exactly what it would be. Disclosure of the royalty payments would destroy the very subject matter of the secret. And the judge then goes on to say, here the most that can be said, the third party's agreed rates are disclosed will be a commercial advantage. I consider that commercial disadvantage to be minor. Well, on what evidential basis could the judge conclude it was minor? He had lots of undisputed evidence saying the exact opposite. But he hasn't actually addressed that evidence other than to say it's not granular. And finally on this, in 31D, yes, 31.4D, sorry. Moreover, it must not be forgotten that all the Apple comparables, as well as the Optis comparables, are coloured by the FRAND background described in Part 1 of the judgment. What's striking about this passage of the judgment is the judge nowhere mentions ETSI's IPR policy, and in particular provisions mentioned by Mr. Justice Mellor, which I've shown to my lords, and which I showed to the judge at first instance, whereby ETSI doesn't require transparency. That might have been thought to be part of the FRAND background to which the judge apparently refers. But the judge has actually gone further in Roman 1 here. I therefore seriously question the commercial importance of these rates, even when the license is current. And the logic appears to be that the mere availability of hugely expensive FRAND litigation in the UK, following the decisions of Mr. Justice Birss and the Supreme Court in Unwired Planet, has somehow changed the global FRAND market in such a fundamental way, or quite fundamental way, as he says there, that the payments actually made cease to be commercially important at all. And the judge doesn't give any reason for thinking that, and with respect we disagree. There is no evidence to support the view that the market has fundamentally changed. And ETSI's FRAND policy envisages licenses being agreed by negotiation, not resolved by litigation. Litigation should be a last resort. Of course, all of this ignores the point that the publication gives the licensee an asymmetric advantage, which would not otherwise have had, as I've already said. And perhaps the point in D2 goes to the heart of the judge's thinking. He believes, line 2, there was a self-evident interest in the publication of these rates in whatever cases happen to be litigated. But as we've said, that's contrary to ETSI's own policy, and it would only provide piecemeal transparency at best. Now, my lords, I've got one eye on the time. I'm almost at the end of this point, and then it's the mistakes.
Right, okay.